let's get on to tonight's webcast. Whether you're a fire ESD or an EMS ESD, the HIPAA law can affect how you operate. Tonight, we're very thankful to be joined by Andrew Tatgenhorst. Did I get that right?
Perfect.
Awesome. Off to a good start. Andrew is from the Underwood Law Firm here in Austin. He'll discuss HIPAA and how ESDs can comply with this very complex law. Andrew graduated from Washington and Jefferson College in 2007. You said that's in Pittsburgh, correct?
Yes.
And earned his law degree at the University of Pittsburgh School of Law. He's an associate at the Underwood Law Firm, specializing in local government law, and we're very thankful to Andrew for being here tonight. And without any further ado, take it away.
All right, thank you so much. I'm really happy to be here. I love the idea of being able to fax in questions. I think that's great. So if everyone would fax in their questions.
Very technologically savvy.
That's right. So yeah, and I want to underscore that I really welcome questions because I think that's a good way to really tailor the presentation. I don't want to just seem like I'm just droning on, which it very much will feel like I'm doing to everyone listening. So please, I think Clay will interrupt me whenever there's questions, but please send those questions along. So as Clay mentioned, I'm with the Underwood Law Firm. We represent a number of government entities, including school districts, ESDs, cities, counties, a lot of local government entities. And so today I'm going to talk to you about HIPAA and what you need to know about HIPAA related to ESDs. So the first thing is sort of what is HIPAA, right? It's the Health Insurance Portability and Accountability Act of 1996. Don't need to really know what that is. That's just a little bit of trivia. You know what the acronym stands for. It basically protects privacy, right? It protects patient information. And really there's three components to that. And the first is privacy, and that is it protects all patient information, ensures that the patient information is kept confidential and secure. And the second piece to that is security. What I'm seeing now is this security piece is really being underscored. When we first passed HIPAA in 1996, the idea was we're keeping patient records confidential. And that is kind of an easy thing to do, right? In 1996, we were talking about actual physical records that we were keeping secure. And so we had to make sure that those were kept private. Now with the increase of cloud storage, computer storage, and all that good stuff, we're seeing that the HIPAA compliance is really taking on a different form. And that is this second area, which is security. And so what that means is that HIPAA is going to require that we increase our security with regard to records, develop policies regarding storage, and safely transmitting all of those patient information records. And HIPAA has been used by the federal government as a sort of mechanism to ensure that those records are being safely stored. So we'll talk a little bit about that. And those are the two primary aspects, right? So the privacy is something I just sort of refer to as sort of, well, that's common sense, right? We all know the privacy aspect of HIPAA. The security aspect, that's number two. That's, again, sort of been a trend of late. And then three is a breach notification, and that is whenever there's a data exchange, we want to make sure we notify the proper folks. And I'll talk in detail about all three aspects of that. All right, so who has to comply? It's really any healthcare provider that charges for services, and this includes EMS, fire departments, rescue squads, and all personnel who work or volunteer for such groups or agencies. ESDs have to comply, so know that and you're good to go. I would also say it includes business associates, and so that would include folks we contract with, right? So any of those folks we contract with that we're acting on their behalf, then that's going to be a business associate, okay? And so all of those agencies have to comply. What I would say with regard to these business associates, when we contract with these folks, I always make sure that we include a provision in there that says that they're going to comply with HIPAA. One reason for that is if we're ever called on it, we can say to OCR or to whomever is enforcing the agreement, we can say, look, we tried, right? When we contracted with this person, we put in the contract that they would comply with HIPAA, and so we did all we could as a government entity to ensure compliance. So make sure that our contracts that we have with these quote-unquote business associates, those folks that are going to see this personally identifiable information, that we're ensuring compliance in that way. So what's the impact on ESDs? Really, this is going to be our EMS personnel. Those are the most likely folks to run into the personally identifiable information. We'll talk about what that looks like. But that's mostly going to be our folks that need to really pay attention to this law, really make sure that we're in compliance. And the reason I say that is those are going to be the folks that have that information that's specific to the patients, right? So it's going to have patient's name, address, their ailments, whatever we're diagnosing, whatever we're treating them with, possibly their history, right? If we're doing a quick history with them, we'll get some information that way. The other thing is HIPAA requires a compliance officer, so we need to make sure that we're designating that person. And so each ESD needs to have a compliance officer, and they must develop operating procedures. I'll talk a little bit more about the procedures. So that person's going to be the person tasked with developing HIPAA compliant procedures, and that's really to sort of develop sound policies and procedures that we can then present to OCR if necessary. The reason I say that, and we'll talk about the enforcement mechanism, but part of this procedure is not only making sure that our folks are following procedures that can ensure compliance with HIPAA, but we want to make sure that if we're developing procedures, those procedures are robust and ensure that we can provide those procedures to OCR, to a court if necessary, and show that we are complying with HIPAA. So it's a vehicle for showing compliance. So not only do we want to make sure our folks are well read in these procedures and HIPAA compliance, but we want to be able to take that and send it along if we need to defend the ESD in any way. One thing we want to underscore is training. You have mandated training, and I would make sure that all of our folks have this training. Anyone that could come across personally identifiable information needs to have training on HIPAA so that they can ensure compliance. These two documents here, you've got a notification of rights and acknowledgement of rights. Every ESD should have one of those. If you don't, you should reach out to your lawyer right away because you need those required notices.
Okay. Real quickly, I do want to interject here. We understand that there is some sort of technical difficulties that we're having right now with the PowerPoint, and that we are working to fix those. The PowerPoint should be available on the website right now, so if you want to follow along and you're unable to read Andrew's PowerPoint, I would advise you to go download that real quick, and we'll keep just heading on through, and hopefully we'll get that issue resolved before too long. But we are aware of the issue, and we're working on it. So anyway, sorry, Andrew, to interrupt you there.
Yeah, no worries. Okay, so in the penalties phase, the reason I try to push this towards the top is really to make sure everyone's paying attention, right? You've got a lawyer coming in to talk about HIPAA, and so want to talk about what it means to violate HIPAA, right? What kind of penalties exist? The first thing I will say is that each ESD should have a policy and procedure in place that requires an employee to comply with HIPAA and to take all necessary steps to ensure that the personally identifiable information of patients is not disclosed. And so if an employee violates those policies or procedures, then I think they're subject to a negative employment action. And that could be a reprimand, it could be suspension, or it could be termination, depending on the level of severity of that offense. So that's sort of the underlying thing, right? I think it's important to recognize that employment action can always take place. Another thing I would say is that if we're embroiled in an OCR complaint and you're negotiating damages in millions of dollars, it's important to understand that termination or some sort of formal action by the ESD can be one way to distance themselves from the action of disclosure. So what do I mean by that? Well, that is the ESD as an entity is trying to avoid any compliance issues, and will say, look, it wasn't the ESD that was acting, it was the employee, and that's a rogue employee. They weren't following policy, they weren't following our procedures, and so we're not liable, it was that employee. And that really goes a long way, certainly in a court, but it certainly can go a long way in a court and could go a long way with OCR as well. There's two basically prongs of liability under HIPAA. and that is civil penalties and then criminal penalties. For our civil penalties, we don't require intent, so just the fact that the disclosure happened is enough to incur a civil penalty. It's a financial penalty, and so we'll talk about the enforcement mechanism there, but basically it's a formal action brought and a actual monetary penalty is brought against the person who disclosed or the entity that disclosed. Another point is that it could also be a licensing penalty, so depending on the particular license that the person holds, that license can be acted upon by whatever organization that is, right? So if it's a nurse, it could be the nursing association and so forth.
So would you say that EMS can be, their EMS license is at stake if in the event of
it surely can be, right? So what that would look like is we would see that entity, the licensing entity, taking the action against the employee, and that's not really something that lawyers get involved with, right? That entity is tasked with ensuring the licensor and all that good stuff. And so, it could very well be that they take that action. Now, I can't speak to how often that occurs, but it could very well occur.
If I'm understanding, you could have an agency problem here where you have the person who maybe made the disclosure, their license is at risk, but also the organization.
Sure, absolutely.
So they can be held accountable on both levels?
Absolutely.
Okay.
I think it's more likely, and I'll talk about the details of this, but I think
Sure.
it's more likely to be an OCR investigation against the entity.
Right.
But I think questions start arising if in that OCR investigation, the ESD as part of its defense is saying, no, it was a rogue employee. I could see that the licensing entity going after that employee's license instead of going after the entity itself.
Got it. Okay.
Okay, criminal violations are for knowing violations, and so that legal standard means that that person was aware of the disclosure and disclosed that person identifiable information anyway. And there's some pretty stark penalties there, and I can't hardly read the slides here. Knowingly is for $50,000 in 1 year, so maximum 1 year in prison. Pretty high threshold, but again, a high penalty. And really, all that is that person was aware of that disclosure and did so anyway. And so it's a sort of a quasi criminal standard.
It's not intentional, though.
Right. Now,
Short,
intentional could be up to 10 years in prison for $250,000 in damages cap. So if there's a demonstration of intent, and that circumstance would be someone deliberately downloading patient information, uploading it, and selling it is sort of what we often see. And so that would be a criminal matter that would be prosecuted.
So we're talking about where somebody intentionally or knowingly is knows that they're going to violate HIPAA or is intending to violate HIPAA.
Right.
Do they have to have knowledge of the law so I guess ignorance isn't a defense of the law, right?
Yeah, no, that's perfect. Well said.
Yeah.
That's a tenet of the law, right? Ignorance is not a defense. So you can't say I was unaware. So the intent would be they'd have to prove that you intended to disclose the information for financial gain.
Okay.
And usually in those cases, that's pretty easy to do because there's a record of them selling the information to some provider that gives them a hefty check in exchange for the personal information. The knowing disclosures, those are a little bit more difficult, and that is sort of they knew the disclosure was going to be, they knew that information was going to be disclosed, and they just didn't stop it.
Okay, that makes sense.
So the good news on that enforcement front is that there's no personal right of action, right? So a plaintiff can't sue an entity for a violation of HIPAA. And that's important, right, because that could lead to a whole area of law where patients are out there suing doctors, hospitals, government agencies, and so forth, trying to seek a remedy under this law. And so this doesn't have that, right? So you have the civil and criminal penalties, and then the enforcement mechanisms that I'll talk about here in a second. That primary enforcement action is action through the Office of Civil Rights. The Office of Civil Rights is a department of the Health and Human Services. They're a division of the Health and Human Services Department, and they are tasked with enforcing HIPAA. So OCR has statutory authority to investigate any complaints and bring those complaints to a resolution. That can mean several different things. One way that they do that is the way a sort of typical OCR investigation works, and I have a little flow chart there for you, is you get a complaint in the mail. They do an intake and review. It's very easy to file a complaint, right? So a plaintiff can easily go on a website and download a form and submit this right to OCR, and OCR will take this very seriously. So they go in, they download the complaint, and it goes through their internal intake and review process. At that point, they'll determine whether or not there's any legitimacy to the complaint. What you'll see is you'll get a request for documentation in the mail. That'll outline exactly what they want from you in terms of evidence, right? So they're a division of the government, so we're not disclosing anything that improperly to them, so they're entitled to this information. And what they're going to do is they're going to look at the information sent by the complainant and information sent by you to determine whether or not there is any violation of HIPAA. I will say they're a little bit of a paper tiger, right? So they have the statutory authority to come in and review records. We often provide those records to them because it's just easier. You don't want the federal government coming through your files and just coming to your site and going through your files, because that's just never a good idea, right? The old axiom, we're from the federal government, we're here to help. The reason I've seen that is in several cases we've seen OCR come on to our site and go through our files, and then they happen upon other violations for other laws they enforce. So we try to discourage that as much as possible. And so what we often do is send them the records they request so that we're working with OCR, and try not to push back too much at that level, because we can sort of tailor the message in that way.
So let me stop right here, because I want to try to distill this into the most simplest sort of way for our folks who don't have a lot of experience in this. When the notice of that somebody's looking into this stuff comes, who's it going to say it comes from? Who is in the return address there?
Yeah, so that's going to be the Department of Health and Human Services Division, Office of Civil Rights.
The federal.
Defense. Yep.
Okay. And who should they call immediately upon receiving that?
So I always recommend calling an attorney at that stage.
Right.
And the reason for that is because we can start tailoring the message at that instance in order to help mount a defense.
Okay.
The reason being is, yes, we're going to end up sending the records they request, but what I like to do is they often ask for they'll go through, we want records X, Y, and Z, X, Y, and Z, and they'll go down the list. There's 15 or so requests. We want all this information, policies, procedures, all that good stuff, and we'll provide that anyway. At the very end, they'll say, okay, and anything else related to this complaint. And so in that anything else related to this complaint, I often provide context. And so it's really, that's our first way of making our case. We're saying, here's what happened, here's why we think we're in the right, and here's why we don't think this is a HIPAA violation.
Okay.
Or what I often do is, thank you for alerting us of this HIPAA violation. We're going to take steps now to make sure that we are in compliance. And so you don't need to do anything, federal government. You stay home.
Right. We've
got this covered. We recognize that's a violation, and we've decided to take this remedial action. And oftentimes what they'll do is they'll say, yeah, okay, great. I like your plan of action, and we won't take this action any further.
Okay. Well, there you go. So,
but yeah, always call your lawyer first, because you want to make sure that it's the cheapest and easiest way is to really get ahead of the curve at that stage, because you don't want to have your lawyers involved in later stages and sort of be behind the eight ball.
Got it.
Let's say OCR does get your documents. They review it. They review all the stuff that they've sent, along with the stuff the complainant has sent, and they're reviewing that information. They're trying to find out whether there's a compliance violation. Once they get there, OCR will do they'll do the investigation, and they'll determine whether or not that information leads to a HIPAA violation. At that point, they'll contact the ESD again, and what they'll say is, we have found a violation, and you need to take remedial action. And what that'll mean is you need to enter into an agreement with us in order to comply with the HIPAA in the future. So it's called a voluntary resolution agreement, but it's not really voluntary, because what they're saying is you either enter into this voluntary resolution agreement or we'll refer this to the Department of Justice, and the Department of Justice will sue that political entity for damages. So it's called voluntary, not really voluntary, but that is a good stage to help resolve this, because you don't want it to be referred to litigation at the next stage. I'm going to go back one slide here. Still looking at that doesn't seem to work. So if at the complaint resolution stage we aren't able to resolve, again, it's referred to the Department of Justice, and the Department of Justice actually initiates litigation. So the Department of Justice will sue that political entity and bring a lawsuit to ensure compliance with HIPAA. The result of that lawsuit could result in a number of different things, including loss of funding, but primarily it involves damages being paid by that entity. I've got on the slides there a screenshot of the OCR website. The OCR is, again, Division of Health and Human Services. They are very public about the resolution agreements that they provide. So every time that they enter into a resolution agreement, they publish this online. And so it's made very public. In some contexts, I haven't seen this as much with Health and Human Services, but the Department of Education's Office of Civil Rights has a Twitter account. And they love to just tweet out every time that they get a new resolution agreement. They simply tweet it out, and it's published on Twitter. And I've seen the Health and Human Services folks do this a few times, so I don't know how prevalent that is, but it certainly could be, right, if someone in their communications office feels like they like that strategy. So be mindful that it is public when you get to the resolution agreement stage, and that is why I like making sure that we try to get ahead of the curve, because you don't want to be on this website, because anyone could just go up and look, and then there's the name of your government entity splashed on the Health and Human Services page. So that's why as soon as you get that complaint in the mail, you want to make sure that you're trying to cut off the investigation at every turn, because you don't want this very public demonstration. I looked up the stats this morning, and we don't have the new data up, but I wanted to just throw some numbers at you and sort of outline how many complaints Health and Human Services gets and how many are investigated. In 2013, they had 14,311 investigations. And
wait, say that number again?
14,311 in 2013.
Okay.
In 2016, it was up to 24,228 cases investigated. I think part of this is that these entities, as they're going through these investigations, are sort of justifying their own existence, right? So they are going through and they're finding violations, and if they're finding violations, then that justifies their existence to the rest of the Department of Health and Human Services. And so it says, hey, look, we're doing our job, we're finding violations, we need more funding, or we need more resources and to get our job done. So I think that's a reflection of what we see there, is sort of justifying your own existence and getting these cases resolved.
So let me ask you this. How does, you may have already covered this, I've been running back and forth with technical issues. How do they decide to, what kicks that off?
So just a complaint from anyone.
From anyone?
Yep.
So anyway, like I could go out right now and complain.
You could go file a complaint, yes.
That somebody has, and I go to HHS basically and say, someone has disclosed my personal information, my personal privacy, private medical information, and that would be one of those 14,000 or 20,
yep,
whatever it was, 1,000. Okay, so.
And OCR has a lot of internal procedures, so they'll get that complaint and they'll analyze pretty quickly whether or not that's a complaint worth looking into or not. And so they justify it on its face whether or not they're going to look into it. Okay. It seems to me, and they don't have the data published online, but it seems to me that they take most of them very seriously and will at least ask for information from both the complainant and the entity to see if there's any compliance issues.
Okay, very good.
I've got a few recent examples just because I think that's helpful to outline. One was a medical group that accidentally posted personal health information for over 6,000 people online. It included patient status, vital signs, medications, lab results, all that good stuff. Note it was accidental. So we're not talking about somebody purposely going out and disclosing this information. There was an error by someone on their tech team where they had some out-of-house information that accidentally got posted to a website accessible by the general public. OCR recently entered into a resolution agreement with that group, and they were issued $4.8 million in fines. So a pretty high number. And I've got another case here out of Texas for a cancer center that was awarded or that was penalized to the tune of $4.3 million. And this, I think, is a good case because it helps emphasize what we're seeing as a trend in HIPAA violations. And in this case, there was the theft of an unencrypted laptop from the residence of an MD Anderson employee and the loss of 2 unencrypted universal thumb drives containing unencrypted public health information of over 33,500 individuals. So someone stole an unencrypted laptop and some unencrypted thumb drives, and because of that theft, they were able to access 33,500 people's public personal health information. So a really pretty big disclosure, right? And nothing the entity did here was particularly problematic, except for they had this unencrypted laptop and they had a policy in place that allowed this employee to take the laptop home, and so if the laptop was ever lost, that person could have access. And again, I'm seeing this trend this is from a case where a judge ruled against the entity, but I'm seeing this in resolution agreements too. We're seeing the folks at OCR going after those folks that don't have what they view as adequate cybersecurity measures in place. And that's just the world we live in. It's 2018, and so that's the easiest way to access this information, the easiest way to disclose it. You could do so accidentally. You could do so because someone steals your laptop. So one thing to ensure we're doing is make sure we're consulting with our folks in the tech world to make sure that our stuff remains encrypted and that we have procedures and policies in place to maintain this personal health information in a secure way. $4.3 million, a pretty hefty fine, and I get that we're talking about 33,000 individuals' personal health information, but they lost one laptop. So it doesn't seem like that big of a deal until that information gets out there. Okay, so the next slide is what is protected health information, and it's basically any medical information concerning a patient's identification. So it can really be anything related to a patient, and I say anything that includes name, address, all that billing information. We'll talk about billing in a little bit. All the information related to that patient's care is of course covered, right? So we want to make sure that all that information remains secure. But that'll include lab results, it'll include invoices, includes everything related to that patient. So everything personally, I call it personally identifiable, right? So if you could determine who that person is by simply looking at this information, then it's protected. I think the best way to just analyze this is just assume that it's covered. That's the easiest way to comply. Assume that everything regarding a patient is covered by HIPAA, and that way there's no concerns about really breaking down what is identifiable or not. Don't even worry about that. Just worry about assuming every single patient's information is covered and protected by HIPAA unless an expert tells you otherwise. So I think that's a good way to operate. Okay, what's the standard for EMS and other first responders? So the law contemplates that EMS don't always operate in the best of settings, right? So they know that you're out in the field and you're dealing with the public health information, and you're not in this sort of sterilized setting that a doctor might be in, right? Where it's a very controlled environment. And so there is some leeway in that sense. What they do is they borrow from the standards across the field. So they will hold all EMS personnel accountable for the standards in that community. So we need to make sure that we're staying up on the latest trends and that we're doing everything that we can do to protect this personal information. One thing I noticed recently was there was a shooting at the Stoneman Douglas High School in South Florida. what I noticed in that news footage is I saw as the EMS folks were responding, and I think some of the fire folks were responding too, once they got onto the scene, they started deploying canopies over a lot of areas. And once I looked into that, it was the procedures that they had developed that once you got into a scene, and it was a scene like that where we knew there was going to be a lot of treatment in the open air, there's going to be a lot of sort of triage occurring, that they have a pop-up tent to help protect from news helicopters or from drones or from whoever. And I thought that was an interesting development, right? There was no HIPAA law passed that said you had to do that, but that was just them complying with industry standard, which is to start doing things like that to help protect the information of those folks. I don't have the slides there. So when can you disclose without patient consent? I get that question all the time. You can disclose to any individual that has been authorized by the patient. They have to fill out a very specific form, and you can only use that authorized form. You can disclose for treatment, payment, or other healthcare operations. So if you need to secure the treatment, so if you're EMS personnel and you're passing off to a patient to a hospital, then of course you can disclose that health information for treatment purposes. You can also do so for payment, right? So anyone that you need to secure invoices to in order to secure payment, then of course you can disclose. And any other healthcare operations, right? So anything related to treatment. One thing we get a question about all the time is disclosure to law enforcement. And this is sort of a tricky sector of law because really it's an intersection between federal law, which is HIPAA, and then state law, which would be any related to law enforcement. And so we can disclose this PHI to law enforcement, but it has to be either pursuant to a court order or when the disclosure is related to a judicial proceeding. And so that is basically you're getting a subpoena. So under those two circumstances we can disclose. There may be another, but I would only talk about any other permutations if you're working closely with a lawyer. All right, when we're talking about disclosures for treatment, we have to comply with what's called the minimum necessary rule. And that is we're only providing the information that is necessary for the provider to complete a task. So we're talking about the EMS context. If we're contracting with someone to do a particular thing, we only provide the information necessary for them to complete that task. So for example, if we're talking about someone that's in our billing department, then they only have to know certain information. They don't have to have the entire patient's history, medical lab results, diagnosis, all that stuff. They just have to have the patient's basic information, right? So that's a good example of the minimum necessary rule. I basically call that the need-to-know basis, right? You can disclose information to those on a need-to-know basis when they need to know. And that's going to be everyone. We're talking about disclosures between first responders, EMS personnel, ER staff, so forth and so on. Disclosure to law enforcement, again, if it's not pursuant to a court order, there's some permutations there regarding the Fourth Amendment, and we've got some discussion there about that. Again, if you're getting into that kind of information, I would just consult with your lawyer just to make sure. The reason being is we represent a lot of government entities, and I often get subpoenas that are not validly issued. And so those need to be reviewed by a lawyer to make sure that they're actually complying. And I say not validly issued, what the plaintiff's attorneys or whomever is subpoenaing the records will try to sort of play games and not validly issue the subpoena, which basically means they haven't notified the other side. And so they're trying to engage in sort of private discovery. And so as a public entity, we just want to make sure that the T's are crossed, I's are dotted, and that we're complying with HIPAA so that if someone did say, well, this wasn't properly disclosed pursuant to a lawful subpoena, we can say, oh, well, we consulted with our lawyer, and so we're in good shape there. So disclosure to family or friends. Look, HIPAA recognizes that some disclosure to family or friends is going to be required and is going to be necessary. The general rule with that is to just use professional judgment, right? So the sort of standard bearer in this section is if the family or friends have come with the patient to seek treatment or with the patient when we got treatment, then disclosure to those folks is likely permissible. I would say be careful about that, right? So if you're talking about disclosure to family and friends in a crowded environment, we want to make sure that we're not disclosing information that could be overheard by others. So they have a classic example, right? If someone in an ER, a doctor talking to a family member and just talking about a status update regarding the patient's condition, that's certainly a lawful compliance with HIPAA, right? We're simply talking to the patient's family member and about an update. That family member came in with the person and sought treatment, and so there's sort of a tacit understanding that, look, disclosure is okay to that person. But be mindful that other people in the room might be able to hear that person, right? So if anyone overhears that person, then that could be a HIPAA disclosure violation. So be mindful of that. Always be mindful of your surroundings. And I go back to the idea of the canopies, right? That was I think an ingenious indication on their part that they're really concerned about patient security and patient identifying records. Another example I had from a case a little while ago was a patient complained of a HIPAA violation where the EMS personnel left an actual clipboard in the dashboard after that patient was treated. I think what happened is they had actual physical papers and they had it on a dashboard, and it was placed just sort of, it was on a notebook, pad, folio, clipboard, whatever you want to call it, and it was placed on the dashboard in the emergency response vehicle. And the patient noticed this, right? And I think that they came up to the vehicle to talk to the folks, and they saw this and they filed a complaint. And that was a complaint, right? They weren't taking the steps necessary to ensure that that information was protected. So the Texas Medical Records Privacy Act, they have added some requirements to HIPAA just to add some layers to this. I don't need to go too much into that, except for, we talked about who is covered under HIPAA. We need to make sure that we're aware that basically any entities that come across this information are going to be covered. So any entity that has this person identifiable information, this health information, if they come into contact with that information, they are covered by HIPAA. So this is Texas law that has sort of gone above and beyond and said, okay, in addition to those covered entities, we've got anyone that comes into contact with this information is covered by HIPAA. Okay, I've got some privacy ethical considerations. One thing that I've noticed a lot of, and this is sort of as the prevalence of cell phones have developed, we've seen a lot of use of personal cell phones by EMS personnel that have we've had some tricky situations with. So that is, you're responding on a scene and someone brings out their personal cell phone to either take pictures or what have you. We want to discourage that, right? And the reason being is outside of HIPAA considerations, your personal cell phone, if you use it for business purposes, could potentially be subject to a Public Information Act disclosure. So if you use a personal cell phone and we don't limit our use and we don't have a specific reason for doing so, it could be difficult to not disclose the records contained on that phone if we get a PIA request. So that's something to keep in mind. The other thing is that it's difficult in the HIPAA context to secure that data, right? So if we're talking about transferring pictures and so forth, then I think there's an argument that we haven't done so in a secure way. So be mindful that we generally recommend that personnel don't use personal cell phones while on the job. All right, I've got a few minutes left, so I want to get into some case studies, which I think will be helpful for understanding some of the nuances here.
I've got them up on my computer since we never got quite the PowerPoints fired up on the screen. Again, y'all should have those out on, where are they? Clip producer, they're under the screen, right? There's a link.
There's a link for all the PDFs.
There's a link for the PDFs under the screen, so hopefully you'll have these case studies too, and I have them here so I can reread them after Andrew goes through them, or Andrew
it's
can
much
read
better.
them.
Yeah. All right.
Here, now you can actually see your work.
Okay, so we've got a what I think is a good case study here. After responding to an emergency situation, ESD personnel go to lunch together. While at a restaurant, they continue to discuss what happened and the conditions of those involved. However, they never mention the names of those involved. So we've got just the discussion about the patient's condition and no discussion of the name of the individual. And so the question becomes, is this a HIPAA violation? And
do I get to answer?
You do.
Okay.
What do
So
you think?
we've got ESD personnel at lunch. They're talking about a call they were just on. They talk about the incident and the conditions, but they never mention any name. I'm going to say no, that is not a HIPAA violation.
Well, and the reason I pick these facts is because I think it's difficult. It's on the line.
Right. Am I wrong?
No, I think that's a defensible situation. So if I got this complaint and we're dealing with OCR, I wouldn't necessarily throw our hands up and say, well, I think we violated HIPAA.
Okay.
What I think we need is some more facts here.
Right.
One thing that I would point out is, look, if we're talking about a small town and that accident is well known and we can find out who that person is, then I think there's an argument for a HIPAA violation, right?
Right.
And so I think the context matters, in other words. And if there's enough details there where we're figuring out who the person is, then I think we can say, yeah, that's probably a HIPAA violation. But theoretically, if you've got two doctors or two ESD personnel sitting at a lunch table in Dallas, for example, in a Metroplex area where you wouldn't be able to know who that patient is,
Right.
then probably not.
Well, one thing I noticed about this hypothetical is that there's no sort of, like, obviously somebody had to hear it, but it doesn't say in here the person who heard it knows for sure what happened, or just that somebody heard it. So we're talking about sort of theoreticals, but we're also talking about, just by doing it, just by having this discussion, that's a violation in and of itself. It doesn't matter if the person around actually doesn't put two and two together.
Exactly.
That only matters for the practicality of what you've got down the line, right?
Yeah, and so that could certainly be evidence, but if that person files a complaint, OCR will look into it.
Okay.
And determine what was said. Now in this case, will they have a lot of evidence? Probably not. It's folks just talking at a lunch table. So there's probably not going to be a lot of evidence of a HIPAA violation.
Right.
So they might be stuck on investigating. But if that person is knowledgeable about who the person might be, then that person can provide more context, more details to OCR, and OCR could then say, okay, I think we have a violation here based on what that person has reported.
So in other words, your folks should be careful if they're going to lunch after a call and discussing those calls, because it could be legit. I mean, you've just responded to an emergency. You've had stuff happen. You want to talk about it, even from a best practices, like, hey, don't do that again. You want to be careful what you say about things and the nature of what's been involved there with the call, right?
Sure.
Even if you're not disclosing names, you can still run afoul for those of you who are especially in those rural and small town areas.
Yeah, and you see that all the time in the more rural areas. It's very easy to sort of figure out, because look, it's a small town, things get around quickly, and so it can be very easy to figure out who the patient was.
Okay, here's our next one. I like these. This is fun. It's like I'm on a game show.
All right, so ESD personnel respond to a terrible car accident. Many news agencies cover the accident and have video of ESD personnel responding and beginning to treat victims. The news video is shared on Facebook, and commenters begin to say that one of those involved in the accident was paralyzed. An ESD first responder sees the video and comments on Facebook, knowing the information to be false. The ESD comments that this information is inaccurate. Is that a HIPAA violation?
Okay, so the ESD first responder, in this scenario, was he on the call?
Yes.
Because he knows that the information's false. I think yes, that's a HIPAA violation.
Yeah.
I would say yeah.
And notice we're not even disclosing anything. All he's saying is that information is inaccurate.
Right.
He's only.
Oh, so he didn't say.
He didn't say here's what it
she or
is.
he is not paralyzed.
Right.
He actually said
That's just inaccurate.
you have inaccurate information, and that alone, HIPAA violation by omission almost.
Right.
Like
Exactly.
He says, that's not accurate. I'm not going to tell you anymore, but that's not accurate. That could be a violation as well.
Sure. Because you're disclosing information related to that patient.
Right.
And part of that information is here's what that patient, doesn't suffer from. And so that's certainly a violation. And I don't think one that you would necessarily think is a violation.
Right.
The other thing I would point out is, let's say that I represented the ESD in this case and OCR was investigating it. I would certainly try to distance myself from this employee. I doubt that the policies of the ESD allow this employee to discuss anything related to their job on Facebook, right? Now there's some First Amendment concerns there, but when you talk about something that's within the scope of their employment, i.e. patients' personal health information, I think there's an argument there that they're acting outside the scope of their employment by discussing that on Facebook.
These things always dovetail into social media at some point.
Yeah, exactly.
Okay, next one.
All right. ESD personnel and hospital personnel have developed a secret code for discussing PHI and places where others might overhear these discussions. For example, as a warning to ESD personnel, they will say high five to alert hospital staff that the patient has HIV or other communicable disease. Is that a HIPAA violation?
Okay, so we've got people, they've got the secret code to discuss private health information in places. They know people could overhear, obviously, and that's why they developed the code. High five to alert hospital staff that the patient has HIV or another communicable disease. High five. I'm going to say yes, because somebody could figure out that code and you're still outside of the scope. I mean, if you do it enough, somebody who just works in the hospital or works around the ESD, an administrator or something, they could figure out that code. I'm sure that gets out. I would say yes.
Yeah, and I think it probably is. Again, need more facts and more context, but if you've got somebody in the hall that could hear that and that can decipher that code, I think it could be. I think what I would point to, to defend those employees would be to say, okay, is there any other way to communicate this information secretly and to make sure that everyone is protected? Because there is a reason for doing this, right? You want to make sure when you're transferring this patient between healthcare providers, you want to make sure that they have this information. I think it's very relevant to the treatment. And so I think it's important that that information is communicated. And if the secret code is the best way to do that, then I think a defense could be made that's best practice.
Right, because otherwise, I mean, you'd have to say, you need to let your fellow colleagues know if there's something like that they should be aware of for a medically valid reason. So
right, and I think I could articulate to OCR and say, the secret code was the best we could do. Right. And so we were trying to be as discreet as possible. Yes, someone figured it out, okay, but we were trying our best, in other words. And, we need to know this information, and the folks that we're passing the patient on to need to know this information. So it could be a HIPAA violation, but I think that we have a good defense in that case.
Right.
Okay, and we've got, I think this is our last one. ESD personnel respond to a car accident to help document the scene and to help the hospital treat the victim. The personnel begin taking pictures of the scene using personal cell phone. As soon as possible, they transfer the pictures to the hospital staff and delete the images. Is that a HIPAA violation?
I know you touched on this in the presentation. So the ESD personnel are documenting with their own cell phones on the car accident. They transfer and delete it. I would say yes, but I think it's defensible because they were doing the best they could. But I think it is because, you could easily, you have it and it's accessed, especially if your cell phone can access the internet or your iCloud or whatever. I would say yes.
So there's two provisions to HIPAA, right? So you've got the privacy, which I think you're probably taking care of here because you're keeping that information private. But I would question the security piece of it. How were these images transferred? Did we send them via personal email? I mean, it's our personal cell phone. So if we go into our Gmail account, that's not secure.
Right.
And so I think that would be the question that OCR might
Yeah,
raise.
if you text messaged,
Yeah.
there's a record of that text message somewhere, right?
Right.
With the image, probably.
Right.
I mean, it's hard to just because you delete it off your personal phone, you still sent that text, and that text it could save in your messages app or something like that. Yeah.
Right. And all that information, from what I understand, is sort of stored in the phone anyway. And so
Mhm.
even if you delete it, there's a record of when the picture was taken and all that stuff. And so, yeah, I think there's some questions there about the security aspect. In the privacy area, I don't know that we've really had a violation. Now, that's putting all the other issues I mentioned earlier aside, the PIA and personnel-related issues, which would be using your personal cell phone while at work and all that stuff.
Right. I mean, we don't want to go into the open records. You just destroyed a record, basically, possibly,
Right.
the AG might say.
So putting all that aside, we're talking about
Mhm.
just HIPAA. I think you could say that this doesn't violate the privacy piece, but the security piece, I think it does, especially when we start looking into, well, how did that transfer occur? Okay, so
Well-
I don't know if we had any questions along the way, but I know I went through that rapidly.
Yeah, we're kind of out of time here. So I will we do have time for a little bit of questions while we're going to do a quick review since we didn't have the PowerPoint up during the actual presentation. I want to kind of try to go over a couple of the high points. If you do have any questions, you can text us at you can text me at 512-567-0857. Normal text messaging rates may apply there. You could call us at 512-251-8101. Email a question at safed@texas.net, or you can go ahead and fax us questions 512-251-8152. So that's the way to get your last minute questions in. Like I said, we are running out of time. Thank you, Andrew, for going through all this. This is incredibly complex, and I think as your scenarios kind of spelled out, this is kind of something that you may think as an ESD provider or an ESD EMS provider, or even if you're just a fire ESD, you might think, oh, well, this doesn't really apply to me. We're not working at a hospital. We're not doctors. We barely deal with the patients, only for a brief time. We don't actually collect too much data on them. All this other stuff. From your scenarios, that seems like that's not actually true. You could easily run into some easy situations. That first one that you had, folks sitting in a restaurant discussing a call,
Sure.
I'm sure that happens all the time.
Yeah.
All over the state, not just in ESDs, but in any department. And my hope would be that your folks are trained, but it's important to understand that you might need some, if you don't already have some private policies for your privacy policies for your ESD. Would that be something you can recommend? Is there a resource that these ESDs can go if they want to develop maybe personnel policies for their folks?
What I often see at the local government level is everyone has a policy from somewhere. I don't know if there's any policy services. I'm sure the municipal league and folks like that have policies. Always have a lawyer review them. So even if you get the policies from a fellow ESD, which we see a lot, right, with local government entities sharing these policies, always have a lawyer review them. There's always intricacies in the law. Laws change. There's case law that develops. Again, with the cybersecurity, we're seeing an increase in litigation over that. So be mindful the law does change. We might need to address the policies or procedures.
I think another thing that I want to hit and make sure gets across is you caught me on that last scenario with, I'm thinking privacy. I'm thinking HIPAA, privacy, disclosures, non-privacy, non-disclosure. That storage aspect is another huge thing, because I know there are records relating to calls that people go out on, and okay, well, you aren't exactly at the restaurant disclosing information or talking about the call, but when you fill out the incident report or whatever you may have, and you leave that somewhere, you store it on a computer, that can go missing. I mean, you just talked about a multi-million-dollar fine. I think that's something interesting that I need to review your storage practices as well, it sounds like.
Absolutely, yeah. And again, we're seeing an increase in OCR taking action in that area. So when the law was first passed in '96, it was all paper records. And so you